Hello, my name is Graham Roberts. I'm a consultant solicitor at Ison Harrison Solicitors. If your employer seeks to dismiss you because you have brought a personal injury claim, that would be unlawful. However, the problem is that you can only bring a claim for unfair dismissal if you have been in employment for 2 years or longer. That means you are vulnerable if you haven't been in employment for 2 years, and although it may be unlawful, your employer may decide that he wants to find a reason to dismiss you and you won't be able to do much about it. It's very unusual for you to claim against a work colleague for an accident at work. If they were acting within the course of their employment and made a mistake which caused your injury, you would normally bring a claim against your employer because your employer would be classed as vicariously liable for the actions of that employee. However, if the employer was not acting within the course of their employment, maybe taking part in horseplay or something of that nature, the employers are likely to say that person is on a frolic of their own and therefore will not accept liability for that accident. In such circumstances, you may have no option but to bring the claim against the person who was responsible. It's much easier to claim for financial losses if you do have documents. That way the defendants or your opponents cannot actively dispute those losses. If you don't have documents, then the only thing we can do is estimate that loss, but then it is open to challenge. An employer cannot contract for their negligence or breach of statutory duty. Although you may be aware of the risks of employment, if they do something wrong and they breach their duty to you, then you're entitled to bring a claim. Yes, you can. This is usually asked in relation to disease type cases or cases where you realise that you suffered an injury or a disease some years after the disease has actually been contracted. There is a mechanism for reinstating a company which has dissolved. The main issue in this is that we must make sure that there was insurance in place at the time that you suffered your injury or disease. Otherwise, there's no use bringing a claim against a dissolved company. Yes, you can. This is normally asked in relation to disease cases such as asbestosis or noise-induced hearing loss. When you contract a disease many years earlier, but do not realise you have that disease until many years later. In such a case, what is important is that you cannot bring a claim more than 3 years after you realise that you have contracted that disease. You would hope that an employer is quite sympathetic that you suffered an injury, you may have to take time off work, and would want to get you back to work as quickly as possible and to get you well as quickly as possible. However, you may get some employees who take it as a personal attack upon them, and it may affect your relationship with them. What they're not allowed to do is dismiss you because you are bringing such a claim. By law, an employer is supposed to have employer's liability insurance in place. This means if an employee has an accident, a claim can be brought against that insurance policy. Therefore, so long as your employer had a valid policy of insurance in place at the time that you suffered your injury or disease, they can make a claim on that insurance, so it should not affect them. If your employer did not have the proper insurance in place, then you would have to bring the claim against that employer directly. Now you can bring a claim for any injury or disease suffered as a result of your activities at work, even those that recover relatively quickly. Again, this is normally in cases where there is a disease that may have occurred over a number of years. If a disease has been caused by a number of employers, usually you will try and divide up the disease by the employers. For instance, with a noise-induced hearing loss case, you may have been employed by employer A for 5 years, employer B for 5 years, and employer C for 10 years. Well, in that situation, employer C would pay for 50% of the claim, and each of the others would pay a quarter of the claim. This would be classed as contributory negligence. And yes, you can still bring a claim even though you may be somewhat to blame for the accident. For instance, in an employer's liability claim, you may bring a claim because you put your own hand into a machine which was unguarded. Well, your employer would be primarily responsible for your accident because there were no guards on the machine. However, you may also be somewhat to blame for the accident because you actually put your hand into the machine. Yes, some people may have policy insurance which pays out when they suffer a particular injury, such as the loss of a limb. If you do have such insurance in place, then by all means you should claim on that insurance. However, you can still bring a claim against the person responsible for that injury. So therefore you claim on your insurance and you bring a claim. Some people may class this as double benefit, but the person who is responsible for your injury is not entitled to claim the benefit of you having taken out an insurance to protect yourself. In an office, it's rare to suffer a type of industrial disease. However, there are some, such as a syndrome called hand and arm vibration syndrome. Included in this is things like tendinitis and carpal tunnel syndrome, usually with typists. All victims of injuries are supposed to mitigate their loss. Your opponents are required to pay for your care if you claim for that privately. However, if you are offered NHS care prior to being able to secure care privately or assistance privately, then you are supposed to take that care, as you are supposed to mitigate that loss. That means to try and get better as quickly as possible. However, you can then alter that care, or you can change the treatment to private treatment once that becomes accessible. If you do require any additional information, then please telephone on 0113 284 5000.